Hello, this is Matt on the Moon Lambeau channel. The most recent update in the SEC versus Ripple lawsuit occurred a couple days or so ago, but what I haven't seen an emphasis on after this news broke is that the SEC is telling the judge that they want to reopen discovery. Yes, for real, discovery, which ended at some point last year. It was actually initially supposed to end, I think, if I'm not mistaken, around August, and it got pushed back. May have been in November. I'm pulling from memory, so it could be slightly off. It had already been delayed. Everything's settled. And now the SEC is telling the judge that they want to open discovery back up. It's completely absurd. And as I've read through the argument that's publicly available to this point, I'm just sitting here thinking the same as I think attorneys within the XRP community are thinking, which is just, this is just pure obstructionism. So I'm going to share with you the specifics of why this is and just how ridiculous this is. And I've also got opinions from a few attorneys, including attorney Jeremy Hogan. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, first of all, shout out and credit to James K. Filan, who is an attorney within the XRP community, who has been sharing these documents, the most recent legal documents, as they come out quite regularly. And there's a couple, this actually isn't very long anyway, but there are just a couple portions of this that I need to highlight and explain what is actually being argued here because it's silly and stupid. And then we can talk about how ridiculous it is that the SEC is using this as some sort of excuse to slow down the case further and reopen discovery because reasons. That's effectively what's going on here. So it reads as follows. Dear Judge Nepern, defendants Ripple Labs Inc., Brad Garlinghouse, and Chris Larson respectfully request permission to serve 2 non-party subpoenas for the limited purpose of obtaining copies of 7 video recordings for authentication consistent with the court's July 19th, 2022 order. Okay, so what they're saying here, effectively, and you'll see as we go a little bit further, what the Ripple wants to do is subpoena 2 parties that have videos that are important to this case. And in order to get access to these videos in terms of actually having them in one's possession rather than just viewing online, you'd actually need to subpoena the parties to get access to them because it's illegal to just download, or at least against it, maybe that's too strong, but it's definitely, if not illegal, definitely against the terms of service to just download these videos without permission. You can use third-party software to do that. It's against the terms of service. And so they're saying, hey, we want to get a subpoena to get these videos that are relevant to the case. And the only way we can get access to these videos, which are highly relevant to the case, is to issue this subpoena. Anyway, and then the writings from, this is from Ripple's attorneys here, that continues, they wrote, the order directed the parties to meet and confer about requests for admission, asking the SEC to authenticate the 7 specified videos in which SEC officials made public remarks, and Your Honor specifically noted in the order that such agreement might entail creating downloaded versions of the remarks for purposes of authentication and preservation. You'll see this is where we get into a little problem territory. You can't have downloaded copies without the permission of the platforms, and they don't name them in this particular legal brief here, but presumably one of them must be, I mean, it is YouTube, right? I don't know what the second one is, but the judge said, hey, yeah, if you can get a downloaded copy, super duper, that would be good. Anyway, and then Ripple's attorneys continue, and they say, the parties met and conferred on July 27th, 2022. The SEC has agreed it will seek to authenticate the remarks once defendants provide them with downloaded copies of the videos, the content of which is already available on the video platform at the hyperlinks provided. So let's just pause here. The SEC can already see the content of these videos in its entirety. So whether they view it online or they have their own personal downloaded copy is of no consequence. This is pure obstructionism. They can already confirm right now, but they're being little baby back bitches and insisting, no, we must have our own copy. But Ripple can't give them a copy unless these platforms give it to them. The only way to do that is if you actually subpoena them, okay? So, but it gets worse. That's why hopefully I'm setting the table and you guys are following me here because it's about to get real bad and stupid. Check this out. Ripple's attorneys continue. The recordings are hosted on 2 video platforms and are subject to those platforms' terms of service, which, based on defendants' due diligence, prohibit end users from downloading their own copies without prior consent. So just pause here. If anything, it makes me think that the SEC was hoping that Ripple would have made a junior mistake here, a little amateur mistake, and just use third-party software to download stuff and then give it to them. And then that would have made Ripple look bad because then they would have gone against these platforms' terms of service. You cannot do that. You're not supposed to do that. It's technologically possible. You're just not supposed to do it, and then that would make them look bad. So by the SEC demanding, no, we need to actually have copies of it, it makes me think, I wonder if they're trying to hope that Ripple would just make a slip up here and actually do it with third-party software. Just wondering. I mean, they're mischievous little F words, so I'm just saying here. Ripple's attorneys then continuing, right? Defendants have thus sought consent from both platforms. Both platforms, in response, have asked defendants to serve a subpoena, in response to which they will provide the video content. So pause. They're just saying that Ripple already contacted the video platform, said, yeah, we'll hand it over, but you gotta send over a subpoena. Okay? And then they write, accordingly, in order to effectuate the parties' agreement on a process for authenticating the 7 videos as contemplated by the order, defendants seek permission to serve subpoenas on both video platforms for the limited purpose of obtaining the videos in question without violating the platform's terms of service. We will then provide the videos of the SEC for authentication. So there you go. It's just Ripple saying, hey, here's the circumstances. We really need to serve a subpoena to do this thing the right way. That's why we're writing to you, Judge, right? This is the part where it gets really bad, though. The SEC is not cool with this. Ripple's attorneys write, the SEC has not consented to this request. Specifically, the SEC has communicated to defendants that it would consent only if defendants agree to reopen discovery so that the SEC could now serve its own set of subpoenas to obtain copies of unspecified recordings in support of its claims, and only if defendants further agree to waive any authenticity and procedural objections to the unknown SEC videos. Pause right there. So this is where they're going off the rails. So there's information already agreed, even after discovery. This is all relevant to the case. It's been determined that is the case. And nobody disputed that. Nobody's disputing that, right? And so the SEC is saying, okay, well, we're okay with these subpoenas being filed, but only if we agree to something completely outrageous, which is we reopen discovery so that we can expand discovery to things that have not been agreed upon to this point. And note that discovery is closed. Like I said earlier, discovery is closed. They're saying reopen it so that they can file their own set of subpoenas to try and get new evidence into the damn case. At this point in the game, can you believe, like, that's why I'm sitting here thinking, like, and this is the millionth time I've said this, but this is how bad these asshat attorneys are. It's just like, if I'm the judge, I'm sitting here thinking, what in the ever-loving hell is your malfunction? You freaking SEC asshat. There's no way that this is some sort of good faith effort. They're acting like little brats, little baby back biatchas, and trying to get new evidence in. Just so that Ripple can comply with an existing court order from the judge. This is offensive on its face. That's exactly. So to reopen discovery? My gosh. It's like, it's not that this hasn't been discussed within the XRP community, but I don't feel like it's gotten like the highlight that it quite deserves. By some it has. By some it has. Most certainly. Like, again, it has been discussed. But like, to me, it's so offensive. I want to put a spotlight on this behavior by the SEC further, which is the reason I wanted to make this video, frankly. Reopening discovery? Are you kidding me? And so here's what attorney Jeremy Hogan had to say about all this. He said, Ripple simply wants to authenticate 7 videos of SEC employees giving speeches, and the SEC is messing around again with it. The SEC played games in responding originally last year. Authentication is standard stuff in litigation and should not be this difficult. Exactly. And again, it's not like they don't have access to these videos. The SEC does right now. They are choosing to be obstructionist about this. They're choosing that. They can absolutely view this stuff. You know, it reminds me of this. Remember this from May? I'm only going to spend a second on this, but my brain went exactly right back here. This is a headline from Cointelegraph, May 20th, 2022. SEC can't confirm if video of Bill Hinman is actually Bill Hinman in Ripple case. Do you remember this? There was a video clip, and Ripple just wanted to. There was the whole request for admission thing, and Ripple just wanted the SEC to admit that an actual video of Bill Hinman is Bill Hinman, and they could not confirm that. They just refused to actually. It was completely absurd. I was laughing, but it was also offensive. Like, there's a lot of times where I feel genuinely like offended as an XRP holder that this is what the government is doing here, but sometimes you just can't help but laugh. Like, what are you going to do about it? You know. And so attorney Fred Rispoli wrote the following. He said, "This is the kind of garbage that pisses off judges. Fights that have nothing to do with merits. Unless Ripple is totally mischaracterizing SEC's position, which is unlikely, and even though SEC continually proves me wrong on this, it can't be this dumb. This is pure childish obstructionism." Well, in a sane world, yeah, I'd say the same thing. They can't be this dumb. But whatever it is, whether you want to call it dumb, incompetency, or purely obstructionist, and I think it's really just them not giving a crap about anything. Like, they don't respect the judge's time or anybody's time or our perspective on anything else because they're sociopaths. I think it's more like that. But they do know what they're doing, as far as I'm concerned. That's my personal opinion here. And then somebody responded to Fred and wrote, "Let's say the odds favored her chastising the SEC again. Is there a criminal code that bars attorneys from pulling this crap? And is there anything the judge can do to punish the SEC from wasting taxpayer dollars in the court's time?" And attorney Fred Rispoli wrote in response, "We are not even close to criminal conduct for attorneys in this case. Hinman conflicts are another story. Most penalizing action Judge Knepper could take is to force SEC to pay for Ripple's attorney fees for time wasting, and we're getting there, so getting closer." And then here's a comment from attorney Bill within the XRP community. He said, "It is not unusual for a third party to ask for a subpoena before producing something to a party in legal proceedings because of terms of service or privacy issues. The SEC's attempt to condition its consent on Ripple agreeing to reopen discovery is predictably completely improper." Well, that's sure as hell how it strikes me. And again, not like I have a legal background, but just as a regular person reading this stuff, I'm like, well, that doesn't sound reasonable. You know what I'm saying? This doesn't make a damn bit of sense, but here we freaking are. Really grinds my gears, folks. Let me know what you think. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.